My lord,
Unmute yourself.
my lord, I will pardon, my lord. Due to some personal difficulties, my lord, item 17 of the weekly list, my lord. Maybe taken up on Monday, my lord. I will argue the matter. Serial number one, maybe it may be listed. Serial number one, I will argue on the Monday, my lord. Item 17.
You have taken the paper book, Mr. Roy.
My lord, I am ready, but due to some personal difficulties, my lord. At least, my lord, Monday, my lord, I have taken all things and I am ready in this matter, my lord. Monday, it may be serial number one, and I will argue that matter on Monday, my lord.
See that, yes.
Oblige.
Item 14. For oral language, and use to oral method.
Which paragraph? This is Arun Bhanudas Pawar. The same judgment you have given.
Yes, sir.
Which judgment you want to place on which paragraph?
Russell Singh Mehra. Paragraph 1. The next page, ma'am. Well,
Yes, which paragraph?
one head, one thereafter head 2. When it is said that a conviction can be, what it doesn't say. When it is said that a conviction can rest on manipulation, it is implied that it must inspire confidence so as to make it safe to act upon it. In that case, if the vital organs of substancing, according to Dr. Devinder Pal, who conducted the postmortem examination of body, were completely smashed, it is impossible to believe that he was in a critical state of mind and body to make any kind of coherent or credible statement relating to the circumstances which resulted in his death. True, he was quite near his creator on the morning of the 30th dangerous injury, so that one may assess that his mind was then free from beliefs which affect the generality of human beings, like involving enemies in all stages. But Sohan Singh, who too ill to entertain any thoughts, good or bad, and he could not possibly have been in a position to make any kind of intelligible statement so as to implicate article number 3 to 9. The time relation cannot therefore be relied upon. In this case, while PW9 came to the spot, she was saying that this is making wrong sound.
Well, in this case, in Darshan Singh.
In that case, madam. In my case. PW9 said, when I went to the spot, that disease was making gong or sound, I gave the water, thereafter she died. That means she was not a free state of mind to make any.
No, what about the dying declaration? The eyewitness account. That they are also the case which you placed. They are also, even though that dying declaration was disbelieved,
Yes.
but the court acted upon the evidence of the eyewitnesses. Here there are two eyewitnesses, PW2 and PW3. So it's a cumulative effect of
Yes.
all the evidence which is to be seen, and each case depends upon its fact and circumstance. So
So far as my IO is concerned, is that the recording of statement and the arrest of the accused. He is saying he arrested the accused. Pressing matter. PW 13 matter. 74 plus matter. 74. And last 7 line. I arrested and got it. I arrested the accused on 595 from inside a jungle near Patamunda village. There was no outsider with me when I arrested the accused at 7 a.m. After 7 a.m. After 7 a.m. at place of arrest, I examined the accused and recorded his statement. When there is nobody. I examined the accused and recorded his statement. The place of arrest is 1 kilometer away from the Patamunda village. Outsiders arrived at the place of arrest and the accused was in my custody till then. Within 2 to 3 minutes of apprehension of the accused, outsiders arrived there. Prior to this incident, there was but he is saying I record the conclusive statement in the presence of the witness. But in the GPS I record the statement of the accused in the presence of the witnesses.
who?
Type before PW8, the independent witness is forwarding the confession and
clearly stated Miller.
IO is PW.
13
13.
Hmm.
When he apprehended the accused person, there was no outsider. It is true. But that is, he told that within 2 or 3 minutes of apprehension of the accused, outsider arrived there.
But in the middle, there are when I record the statement, there is nobody.
There was the persons who are present, they have also recording that statement, they have put their signature.
Signature on that.
That when he brought the accused to the place matter, to the spot.
No, at the time of arrest of the accused, it is not necessary to be there anybody. What is the necessity?
When the
only when
recording was done, there it is.
His source of knowledge is a.
Yes, Mr.
Yes, sir, that is.
You argue the matter. Yes, Mr. Tripathi. What is your submission?
According to the eyewitness COARAM declaration,
Eyewitness are PW 2 and 3.
2 and 3.
1, 2, and 3.
The 1 is not 2 and 3.
Yes, sir. 2 and 3. The category is stated there. That I am reading that portion. I know the accused, I know the deceased.
You are reading which part?
PW 2.
PW 2 page 48.
I know the accused, I know deceased Mangal Munda and his wife Raja Munda. I know Mongolu Munda informant. About 1 year back at 10 a.m. I had come to the house of Mangal Munda for my wages, as I had heard earlier in history. Mangala was present outside of the house and his wife was present inside the house. While I was talking with Mangal outside the house, I found accused standing on the road, being armed with an axe and was looking to all sides. Then the accused came inside the premises of the house of Mangala and assaulted by said axe to the neck of Mangala. Thereafter, I fled away from the spot out of fear. No other person was present except wife Mangala.
So this man, this
I've seen that.
PW2
Yes.
has only seen the part of assault on the
Yeah.
Mangal, right?
Neck.
Right.
Yes.
But when he left the spot, the presence, the accused was there,
Yes.
and thereafter, so the possibility of other assault on the Mangal, so also on the Raja Munda, which has been deposed to by the PW3.
Yes.
That
And
is,
apart from that,
yeah.
that he was identified the axe. This person to PW2. This is that the axe which the accused was holding by and by which the assaulted Mangal. They move on. And then came to PW3. The mother of the accused, the sister of my father-in-law, Mangala, had married Raja, who is my niece. Mangulu is my eldest son. Since about 3 years, Mangala and Raja are dead. While I was sitting on the tree, I found Raja running towards our house, being chased by the accused. Accused assaulted her neck by back of an axe. First accused assaulted Mangala by axe and then chased Raja to assault. Mangala and Raja died due to assault by the accused. Jaga fled away from the spot.
So the weapon,
No doubt that is axe.
that was the that is an axe.
Yes.
Which was identified by the eyewitness PW2.
Yes.
Was produced by the appellant on the basis of his statement recorded under section 27 of the Evidence Act. And the said axe was also sent to the doctor who conducted the postmortem examination, that is PW12 and PW14.
Yes.
And they have examined and said that the injuries are possible by it. Right?
Yes.
The actor sent for after 2 months, right?
That has not come. We are not on the C report right now. It is not with us.
PW and they are saying that we are inside a house at the time of occurrence. PW5 and PW1. And the hearing shouting of my mother, we were going to respond.
PW5 has not
Sorry,
stated.
PW1.
No. PW5 has not stated about any groaning sound. No groaning. PW9. बुधनी को होती
Page 63, ma'am.
The assault which was given to this lady, which has been deposed to by this PW14, that shows that on the back, right side, etc., the assault was made. There is nothing that the neck was caught or something like that. So it depends upon on which part of the body the assault was made and what is the resistance, power of resistance of that person, how much time he can survive. So that case, that was a different, maybe on the facts and circumstances of the case, that observation which was you placed, that was made, because
In that case,
it appears that the vital organs, the doctor's evidence, peritoneum, stomach, spleen were completely smashed, and there was remote chances of remaining conscious after receipt of injury number 3. That is to say that these are the evidence of the doctor there. The doctor PW2 who examined the deceased, he has stated like that. So that was a different, they held that it was not in the fit state of mind and body to make the coherent and credible statement. Here it is something different. From the PW14 indicates at page 76 that one inside wound is on the back, the second inside wound is also on the back, third is on the right side back, fourth is on the back, fifth is on the back right side, sixth is on the left arm, and there was fracture of ninth and 10th rib. All these injuries so and so and possible by so and so. So it depends. These injuries varies from the injuries which you find that, and if that would have been the state of affair, something would have been elicited from the doctor that after receiving such injury, there was no possibility on the part of this deceased to survive for even for a moment, and he would die immediately. And in such a state of affair, it would not. So all these things, it was required to be brought from in the cross examination. Unless you bring it, you cannot, just because in one case it has been held like that, because the evidence of the doctor in that case was like that, in such a state of affair, there cannot be any current state of mind. So the factual aspect is completely different. You cannot compare the two cases like that. Principle is, it all depends upon about the factual aspect. In a little change of fact, the ratio may not apply. And even if the doctor would have stated so, that cannot be the final thing, because it is after all the person who has received the blow. It depends upon his power to receive the blow and to survive. So doctor is just opinion evidence.
Without 14 days, better is the sense.
All right, but a substantive
They
evidence cannot be
all they have the experience.
Yes.
There is a in the MBBS course, they used to go through a forensic science laboratory course, and they are in the practical side also they had experience. So all right, so that's all.
Yes.
দেখুন, JCRL number 47. Please take down. Please 47 2008. The appellant Joglo Munda face trial in the court of an additional session judge Talche in criminal trial bracket case number 2 of 2006. For offense punishable under section, please take your seat, 302 of the Indian Penal on the accusation that on 1/9/2005 at about 12 noon at Patamun under Palhara police station, he committed murder of Mangal Munda, bracket D1, hereafter the deceased D1, deceased D1, and Raja Munda D2. The Lennon trial court by judgment and order dated 29/4/2008 found the appellant guilty under the offence charge and sentenced him to undergo imprisonment for life and to pay a fine of ₹5,000 in default of payment of fine to undergo RI for 1 year. The prosecution case, as per the first information report, bracket Exhibit 1, lost by Mangalu Munda, bracket PW1. Before the officer in charge of Palhara police station, in short is that on 1/9/2005 at about 12 noon, while D1 was present, D1 who was his neighbor was present in his courtyard. The appellant reached there holding an axe and dealt repeated blows on D1 on his neck and back, as a result of which D1 died at the spot. At that time, the wife of D1, that is D2, arrived at the spot and the appellant also chased her and assaulted her on the neck and back with the axe and fled away from the spot. The sister-in-law of PW1, namely Buduni Munda, bracket PW9, who is the wife of the younger brother of PW1, was returning home at that time from the field, and she noticed D2 in an injured condition and gave some water to her, and D2 disclosed before PW9 that the appellant assaulted D1 as well as her, bracket D2, by means of axe, and within a few minutes D2 died. PW1 was not present at that time, and when he returned home after finishing his cultivation work, he came to know about the occurrence from PW9 and also saw both the deceased lying with bleeding injuries. And there are injuries on the back, neck, and other parts of the body with sharp cutting weapon. And the apparent had absconded. PW1 came to the Palhada police station and orally reported the matter. Before PW13, the officer in charge of Palhada police station, who reduced the same into writing and read over and explained the same to PW1. And after PW1 admitted the same to be correct, on the basis of the written report, Palhara PS case number 55 dated 1/9/2005 was registered under section 302 of the Indian Penal Code against the appellant. PW13 himself took up investigation of the case. During course of investigation, he examined the informant PW1, visited the spot and prepared the spot map exhibit 9, conducted inquest over the dead body of D1 and D2 as per inquest report exhibit 2 and exhibit 3, sent the dead body of both the deceased for post-mortem examination, seized the Bloston earth and sample earth at the spot and prepared seizure list exhibit 4. So he also examined other witnesses and seized the wearing apparels of both the deceased on being produced by the Havildar after the post-mortem examination. On 5/9/2005, the IO bracket PW13 arrested the appellant from inside a jungle near Patamunda village. And the appellant not only confessed his guilt, but disclosed that he had concealed the weapon of offense, that is axe, in a bush of Ugura Tunguru forest, and further stated that he could give recovery of such axe on the basis of the statement of the appellant, and as he led the police party and the witnesses to the bushy jungle of Uguru Tanguru. comma, the weapon of offense, that is axe, was seized by the IO in presence of the witnesses, which was produced by the appellant by bringing out the same from the books as per seizure list exhibit 6. The appellant was forwarded to court. The IO received the post-mortem report and made a query to the medical officer who conducted the post-mortem examination of D1 and D2 regarding possibility of injuries sustained by the deceased persons with the seized axe, and received the query report, and he made a prayer to the court to send the seized exhibits to SFSL through SDGM Palhada. Court letter SDGM Palhada. And accordingly, the same was done. On completion of investigation, PW13 submitted charge sheet against the appellant under section 302 of the Indian Penal. The case was committed to the Court of Session after complying the procedure, where the learned trial court framed charge as aforesaid. The appellant pleaded not guilty and claimed to be tried, and accordingly the sessions trial procedure was resorted to prove his guilt. The defense plea of the appellant was one of denial, and it is in the last question on the accused statement, the appellant stated that since D1 had earlier assaulted him on his head, he bore grudge on D1 and accordingly assaulted D1 and D2 with Tangia, for which both of them died. In order to prove its case, the prosecution examined 14 witnesses. The prosecution also exhibited 15 documents. The axe was marked as MO1. The Lennon trial court, after analyzing the oral as well as documentary evidence on record, came to hold that from the evidence of the two doctors who conducted post-mortem examination, the prosecution has proved that death of D1 and D2 to be homicidal, and that the injuries found on the dead body could have been caused by the axe MO1. The Lennon trial court has considered the evidence of two eyewitnesses, that is PW2 and PW3, and came to hold that the evidence of PW2 and PW3 clear, consistent, and trustworthy. Their evidence gives a ring of truth, and those witnesses have no acts to print against the appellant so as to falsely implicate him in the commission of murder of D1 and D2. And though some minor discrepancies are there in the evidence of PWs 2 and 3, same do not have any intrinsic value so as to discredit their testimonies. The London trial court discussed the evidence of PW9 was stated about the oral dying declaration and accepted her version. The evidence of PW8 and PW13 regarding the appellant leading to discovery of the weapon of offense, that is Arts MO1, has also been accepted. It was further held that from the evidence of PW7 and PW11, it appeared that there was previous enmity between the appellant and the deceased D1, and the appellant threatened to kill the D1 and D2, and that was the motive for killing both the deceased by the appellant. The London trial court further took into account the admission of the appellant regarding killing both the deceased in his statement recorded under section 313 CRPC, wherein the appellant categorically admitted that prior to the occurrence, the deceased D1 had assaulted him and caused head injury to him, and due to the said gross, he assaulted D1 and D2 with axe, as a result of which they died. The London trial court came to hold that the prosecution has proved its case beyond all reasonable doubt that the appellant has committed the murder of both the deceased and found him guilty under section 302 of the Indian Penal Code. Mr. Satyanarayan Mishra, bracketary 4, the London counsel for the appellant, argued that In view of the discrepancies appearing in the evidence of two eyewitnesses, that is PW2 and PW3, the London trial court should not have placed reliance on their testimonies. It was further held that the injuries sustained by D2 was so serious that she would have died instantaneously and would not have survived to make oral dying declaration before PW9, and the London trial court should not have accepted the evidence in that respect. It was further argued that though it is the case of the investigating officer PW13 that the appellant made statement before leading to discovery of the arts, but the statement has not been recorded, and the weapon of offense was produced before the doctors after 2 months of its seizure, and there is no clinching evidence as to why it was produced at such a belated stage and in what condition the axe was kept prior to its production before the medical officers to give their opinion. And therefore, there is every chance of tampering with the seized axe. And moreover, when the C report has not seen the light of the day, no importance is to be attached to the seizure of the axe. The Land Council submits that if the evidence of the eyewitnesses are discarded and the version of PW9 regarding oral dying declaration becomes doubtful, and on account of belated production of the seized axe before the doctors and non-production of the C report, no importance is to be attached to the seizure, then there is nothing left in the prosecution case, and therefore it is a fit case where benefit of doubt should be extended in favor of the appellant. He placed reliance in the decision of so and so, reported in so and so. The Mr. Tripathi, London Additional Standing Counsel, on the other hand, supported the impugned judgment and argued that the houses of PW2 and PW3 are close to the spot, and therefore the presence of both these witnesses cannot be doubted. He further argued that PW2 has only seen a part of the occurrence, and he left the spot after D1 was assaulted out of fear. But PW3 was present throughout, and he had seen how both the deceased were assaulted by the appellant with axe. The London Council further argued that the evidence of these two eyewitnesses, so also the evidence of PW9 was stated about the dying declaration, is getting corroboration from the medical evidence, and both the doctors that is PW12 and PW14, who have noticed number of cut and incised wound on the body of the deceased, have stated specifically after examining the seized weapon of offense that the injuries sustained by the deceased are possible by such weapon, and the survival of D2 for some time after receiving the injuries depend upon her strength and power of resistance, and therefore it cannot be said that after receiving the blows with axe she would have died instantaneously, and there was no occasion to make dying declaration before PW9. Mr. Tripathi further argued that even though the C report has not been produced, the evidence available on record is sufficient to find the appellant guilty under section 302 of the Indian Penal Code, and rightly the Lennon Trial Court found the appellant guilty of such offense, and therefore the appeal being devoid of merit should be dismissed. Adverting to the contention raised by the Learned Counsel for the respective parties, let us first examine as to whether the prosecution has successfully established that both D1 and D2 have met with homicidal death or not. PW12 is the surgery specialist attached to SDH Palahada, who conducted postmortem examination for the dead body of D1 on 2/9/2005. And he noticed the following injuries on D1 and opined that the injuries were antemortem in nature, and the cause of death was hemorrhage and shock due to the injury to the neck vessel and neurological shock due to the injury to the spinal cord at the root of the neck. The death was homicidal. The report was postmortem report was marked as Exhibit 7. The doctor has also examined the axe which was sent by the IO PW13 with a query whether the injuries found on the body of P1 would have been inflicted by that axe, and after examining the axe and going through the PM report, PW12 opined that the injuries found on the body of D1 would have been inflicted by the axe, and the query report has been marked as Exhibit 8. The doctor has also stated that he gave the opinion after examining the axe bracketry MO1. Though the doctor has been cross-examined at length, but nothing material has been elicited in the cross-examination to disbelieve the evidence, the medical evidence. Similarly, PW14 were the pediatric specialist attached to Subdivisional Hospital, Palhada, conducted postmortem examination over the dead body of D2 on 2/9/2005, and he noticed the following injuries. Quote the injuries. He noticed the fracture of 9th and 10th ribs posteriorly on the right side. All the injuries were opined to be antemortem in nature, and the injuries were sufficient enough to cause severe hemorrhage leading to death. The cause of death has been found to be due to hypovolemic shock due to profuse hemorrhage from the wounds. The postmortem report of D2 was marked as Exhibit 15. PW13 also produced the arcs bracketry MO1 before PW14 for its examination and to give opinion about the possibility of the injury sustained by D2 with such arcs, and PW14 on examining the arcs and the injury sustained gave his opinion that the injuries found on the dead body of D2 can be caused by such arcs. The query report has been marked as Exhibit 13. Nothing has been brought out in the cross-examination of PW14 to disbelieve his evidence. Therefore, from the inquest reports of both the deceased, coupled with the evidence of the doctors PW12 and PW14, and the postmortem reports Exhibit 7 and Exhibit 15, we are of the humble view that the Lennon trial court has rightly arrived at the conclusion that the prosecution has successfully established that both the deceased met homicidal death. The next part, the prosecution case also rests also on the evidence of the two eyewitnesses, that is PW2 and PW3. PW2, Gora Munda, has stated that on the date of occurrence, he had come to the house of D1 for his wages, as he had worked earlier in the field of D1. And D1 was present outside the house, and D2, who was his wife, was also present inside the house. And while he, bracketed PW2, was talking with D1 outside the house, he noticed the appellant standing on the road, being armed with an axe. And suddenly, the appellant came inside the premises of the house of D1 and assaulted D1 with the axe on the neck. PW2 has stated that seeing such assault, out of fear, he fled away. And as soon as the appellant assaulted the D1, he called D2, who came out, and thereafter he fled out. The witness has identified the axe which was used by the appellant for assaulting D1, and the same has been marked as MO1. The learned counsel for the appellant contended that since since PW2 has not stated any assault on D2 and he left the spot immediately, the evidence of the prosecution case that DW that the appellant also assaulted D2 cannot be accepted. The learned counsel further argued that the presence of PW2 has not been deposed to by PW3, who is an eyewitness to the occurrence and stated to be sitting under a tree and watching the occurrence right from the beginning till end. The eyewitness PW3 has stated that while she was sitting under a tree, she found the appellant chasing D2 and the appellant assaulted D2 on her neck and back by an axe. She also stated that at first the appellant assaulted D1 by an axe and then chased D2 to assault. And both D1 and D2 died due to the assault of the appellant. And the appellant fled away from the spot. Since PW2 left the spot immediately after the first blow was given by the appellant on the neck of D1, and it appears that D1 has sustained other injuries, and while leaving the spot, DW2 called D3. PW2 called D2. Therefore, the PW3 seeing the assault on both the deceased cannot be an improbable feature, and that there cannot be said to be any such major discrepancies between the evidence of PW and PW3 merely because PW3 has not stated about the presence of PW2 at this spot. The same cannot be a ground to disbelieve the evidence of either PW or PW3. It depends upon the eyewitnesses to the occurrence as to what part they are focusing at the time of the occurrence. The sitting of PW3 under a tree might have missed the notice of PW2, and therefore the same cannot be a ground to disbelieve the presence of PW3. The two witnesses are independent witnesses, and they are the co-villagers whose houses are in the neighborhood of both the deceased, and they have no acts to grind against the appellant, and therefore stop. The doctor's evidence also indicates the number of injuries sustained by both the deceased, and all those injuries were possible by sharp cutting weapon, and the doctors, after examining the weapon of offense, that is axe bracket M1, seized, have opined that the injuries caused to the deceased D1 and D2 are possible by such acts. Therefore, the evidence of the oral accounts of the PW2 and PW3 is getting corroboration from the medical evidence. And we are of the view that the London Trial Court has rightly placed reliance on the evidence of these two eyewitnesses. Coming to the evidence of PW9, she had stated that on the date of occurrence, after weeding operation in her land at about 12 noon, she returned to her house and found D2 lying under a tamarind tree. And she thought perhaps D2 was suffering from fever, for which she went to see her and found her with bleeding injuries on her back. And D2 told her that the appellant had assaulted her by axe, and then she gave some water to D2, but she died. PW9 further stated that D2 also told her that first D1 was assaulted by the appellant, and then the appellant assaulted her. PW9 further stated that she went to the house of D1 and found injuries on the neck of D1, and there was blood clotting, and he was dead by then. PW9 further stated that he told about the occurrence to PW1 and PW5. PW1 is the informant in the case, and he has mentioned in the first information report to have heard about the occurrence from PW9. Similarly, PW5 has stated that when he reached home at about 12 noon, PW9 informed him that the appellant assaulted D1 and D2 by axe and had killed them and fled away towards Joutukonar. And she further stated that after taking her bath while she was coming to the house, she found D2 was lying in an injured condition and bleeding condition, and seeing uh, PW9 when D2 asked for water, PW9 gave her water, and on her query to D2 as to who assaulted her, D2 disclosed that the appellant first assaulted D1 and then chased her to assault, and while she was running towards her house, the appellant assaulted her and fled away. Therefore, the oral dying declaration, which is of D2, which is deposed to by PW9, is getting corroboration from the evidence of PW1 and PW5. The learned counsel for the appellant placed the decision of the Honorable Supreme Court in case of Darshan Singh versus alias Bhashuri versus State of Punjab, reported in AR 1983 Supreme Court 554, where the learned court has been held, pleased to hold that the conviction can based on the dying declaration. It must inspire confidence so as to make it safe to act upon. In the said case, after assessing the evidence of the doctor, bracket PW2, who conducted postmortem examination over the dead body of the deceased, which showed that the vital organs like peritoneum, stomach, and spleen were completely smashed, and that there was no remote chances of his remaining conscious after receipt of injury number 3, that is, injury on the left iliac fossa, which caused fracture of the spleen. The Honorable Court held that it was impossible to believe that the deceased would be in a fit state of mind and body so as to make coherent or credible statement relating to the circumstances which resulted in its death. In the case in hand, D2 was examined by PW14, and the injuries which were noticed on D2 were either on the back or on the left arm, and nothing has been brought out from the evidence of PW14 by the learned defense counsel that after receiving the 6 external injuries, including the fracture of 9th and 10th rib posteriorly on the right side, there would be no chance of survival of D2 and he would instantaneously die. In absence of such evidence, when it depends upon the person who has sustained the injuries, his power to bear the blows and power of resistance and time of survival after receipt of the injuries, we are not able to agree with the contention raised by the learned counsel for the appellant that immediately after receipt of the blows by the acts, there would have been immediate death of D2, and therefore he would not have been a position to make any dying declaration before PW9, and that for such reason the oral dying declaration is to be discarded. We are of the view that the London Trial Court has rightly placed reliance on the evidence of PW9. Now coming to the evidence of the leading to discovery of the arcs at the instance of the appellant, the IO bracket ray PW13 has stated that after the arrest of the appellant on 5/9/2005, he not only confessed his guilt but disclosed that he had concealed the weapon of offense, that is axe, in a bush of Hugura Tunguru forest, which is at a little distance from village Patam, and he was told to give recovery of the axe if it would be taken there. And accordingly, he led the police party and other witnesses to the bushy jungle of Huguru Tanguru, and from a bush he brought out the axe, which was seized by the IO in presence of witnesses Dukhiya Devuri and Guru Charan Pradhan as per seizure list exhibit 6. The aforesaid two witnesses have been examined by the prosecution.
Only one.
Out of those two witnesses, PW8, Dukhiya Devuri has been examined as PW8. And he has also stated that the appellant confessed to have concealed the weapon after assaulting both the deceased, and led the police to the jungle and brought out the axe from a bush, and he also stated about the recording of the statement of the appellant under Exhibit 5. Exhibit 5 টা হচ্ছে statement of that
That place is the open place and
just
automatic.
the contention of the London Council for the petition appellant that the place was open place and accessible to all cannot be a ground to disbelieve this evidence in view of the fact that it was hidden inside a bush and it would not be ordinarily visible to the other person, and it was within the exclusive knowledge of the appellant as to where he had kept the axe. It is of course correct that the it is of course correct that the axe should have been there should have been the evidence of adduced by the prosecution that after its seizure the axe was kept in sealed condition, and it was produced before the doctors for giving the opinion, and there is no such evidence, and there was also no evidence as to whether the seized axe contained any bloodstain or not, in as much as the prosecution has not taken any step to produce the C report, even though the axe was sent for C examination along with other exhibits. But when the we have accepted the eyewitnesses account, so also the oral dying declaration, and we found that the evidence adduced by the prosecution in that respect is creditworthy, and um, the evidence has not at all been shaken in the cross-examination. We are of the view
My submission
Yes.
that the
my submission is forwarded by PW6.
London trial court has
PW6.
rightly held the appellant guilty under section 302 of the IPC, and accordingly the appeal stand dismissed. The impugned judgment and order of conviction by the trial court stands confirmed. You are on bail, the appellant?
No,
Where is in custody court?
Yes, ma'am.
देख ले bail हो चुकी है.
Yes, ma'am. I was on bail and
Yes.
his whereabouts is not known.
All right. The appellant is on stated to be on bail. He should be immediately taken into judicial custody. Yes. Who order ହେଇଥିଲା ଦେଖିଲେ High Court ର bail ଦିଆ ହେଇଥିଲା High Court order ଚାଲିଛି.
Nine.
Admit call for this one so prepared. No,
No, he is in
that is
custody.
President.
He is in custody.
But I
Yes.
received a instruction from the IAC
Ah.
that his whereabouts is not known.
No, if he had been released prematurely, we do not know. But from the record, at least this court has not granted bail to him. Okay. All right.
Okay.
Next.
Item 12, ma'am.
Hmm.
Well,
If you have the political
hmm.
important points to the 2.0. Yes, what is
We have asked for that. Inna alias Kamalakant from Molly.
ଦିଅନ୍ତୁ ଆପଣଙ୍କର instruction ଟା ଦିଅନ୍ତୁ. As for the order dated 21/11/2023, the London Council for the State has produced the written instruction received from IAC Dusuri Police Station that the appellant Hina alias Kamalakant Mali is dead since 8/11/2017. The death report has also been annexed with the written instruction. देखिए कुछ कर देखिए. Section 394 of CRPC states that every appeal of this nature shall finally abate on the death of the appellant. Since no near relatives have preferred any application for leave to continue the appeal and the appellant is dead, the jail criminal appeal stands disposed of. Yes, any other London Council, Mr. ଆଗରୁ ଆରମ୍ଭ ହେଇଥିଲା ନା ଆରମ୍ଭ ହବ? कौन ପାଇଁ ରହିଥିଲା ସମୟ ହେଲାନି ନା କଣ? So Mahanti, what is the full name? P-U spell P-U-L-E L-A K-E-S-S, na? Mr. Tripathi, you will do this matter.
Yes.
Over there. There was injury to the head and it was laceration. Whereas the that was not for the exception. The whatever things that were not right. So the question was that that the place of injury is that it cannot be that laceration that no probably with some
Yes, have you brought out those decisions? The eyewitnesses are PW9 and PW15. They both of them have stated that it is you who assaulted the deceased by
Odisha.
that is a sharp cutting weapon. No?
Yes.
Gote side re blunt rohita hai. So se pehla, please come to the evidence of PW9. Good. Yes.
So all the active persons present in the dock. So witness named all the active persons and identified them at the dock. They are my co-villager. This is Ananda Naik, is my father. I am the informant of this case.
Four persons were facing trial.
Yes.
3 of them have been acquitted.
The occurrence took place in 22/8/2003 at about 7 a.m. morning in our village London. On the previous day of the occurrence, I came to know that accused Chittararanjan was selling liquor at Tikubandha Chakra, which is situated at the end of our village. So I, being the member of the village committee, went there and requested the accused not to sell liquor. When I requested the accused Chittararanjan not to sell liquor, the accused Chittararanjan, Vasanta Naika, Pandava Naika, and Cherugoda quarreled with me there at Tikubandha. Thereafter, I returned to my house. On the next morning, at about 6 a.m., that is on the occurrence day, all the accused persons came near to our house and quarreled with me. All on a sudden, accused Prabhachi Nagar gave 2 to 3 fist blows on my nose.
He has been acquitted.
Yes. Thereafter, the other 3 accused persons, namely
Chittararanjan is the appellant and
Bhaskar Naik and Palash,
they are acquitted.
surrounded me. At that time, my father Ananda Naik was coming towards me. Seeing my father, all the accused person left me and rushed towards my father. At that time, the accused Chittararanjan was armed with Odisha and other 3 accused persons were armed with Khenga. Accused Chittararanjan assaulted my father by means of Odisha on his head. As a result of my father fell down on the ground, and thereafter other 3 accused persons assaulted him by means of Khenga. While my father was lying on the ground, the accused Chittararanjan stabbed the Odisha on his abdomen, causing bleeding injuries. My father had sustained severe bleeding injury from his head. My father was attacked by accused person near a coconut tree in front of the house of Soma Naik and Vishnu Naik. Thereafter, the villagers came to the spot and seeing them, the accused person fled away taking their instruments. Immediately after the occurrence, my father died at the spot under the coconut. I requested our Sarapancha Uchchava Naik to scribe the FIR. Accordingly said Uchchava Naik scribed the FIR as per my instruction
and thereafter he read over and explained the content thereof, and being understood the content thereof, I put my API in the said FIR in the video. Thereafter, I lodged the FIR at Patapur police station on the same day at about 10 a.m. This is the FIR marked as I was also examined by the doctor for my injury on police requisition. I had sustained injury on my nose and right shoulder. Cross-examination. No, just this person, this eyewitness, so far as this appellant is concerned, he has stated that with that he has assaulted. First blow was on the head, right? The next blow after he fell down on the abdomen, and the other three accused persons who were acquitted, they also assaulted the deceased, but by means of thenga. So the injuries that is the doctor is PW2, na? Two. Okay. PW2 has stated what injuries he has noticed. On the scalp. Okay.
He's not saying about any other.
So that means the injuries, which is the assault, which has been allegedly caused by the three accused persons, the three accused co-accused persons, that there is no corroboration from the medical evidence, and perhaps that may be the ground of acquittal of those three accused persons. So it is a, I think the question that was put to you is that Gadisha, somebody has described that what is that weapon, how it looks like, what is the, there is
Paravan, the injury number 2 would have been caused by a moderately heavy, multi-edged, pointed weapon. Doctor Paravan, opinion. 57.
Examination of the weapon provided
Moderately.
The examination of the weapon of offense provided along with the body of the weapon, called locally as Kidisa, having a bamboo handle, having 7 nodes. And 7 internodes alla. Taro length alla etiki 150 cm. Maximum circumference with metallic pointed blade. Blade length and maximum circumference was
Pointed tip.
And opinion he has given that the weapon containing bloodstain and above so and so injuries can be caused by the provided weapon. The weapon is handed back to the police. So he has given a positive opinion in that it is possible, both the injuries are possible by such. That's a different matter, but so how far you have succeeded in the cross-examination to demolish the version of this PW9 and eyewitness to the occurrence? PW15 has different story. PW15 different story mane kon? Just please place that away. Page 91.
I know the complainant, the deceased Ananda Naik and the accused persons of this case. The occurrence took place 4 years back. On the date of occurrence at 7 a.m., I was cleaning my cycle on my front veranda. At that time, the complainant and one Basanta shouted quarreled in front of the house of Nakula Naik of my village. Hence, Nakula Naik, father of the Basanta, came there and photoed of Pramod Naik. At the time, accused Chitra, Prabhasi, Bhaskara and Palasar assaulted Pramod. On our protest, they shouted with us.
These are all the accused persons.
Yes.
Chitra is the appellant, and the other three, Paravasi, Bhaskara, and Palasar, are the co-accused who have been acquitted, right?
They assaulted Pramod.
That is the first part of the offense. Yes, then
The one part says it at home. PW9.
ठीक है, अपन second part को आसुन. घटना है जिसे अपन और there
in front of the house of Vishwanath. Again, the accused person picked up quarrel with the complainant. At that time, Ananda Naik, the deceased father of Pramod, came there, but accused Chitra dealt a blow on the head of the deceased Ananda by a Odisha and thereafter pierced the Odisha on his belly. As such, Ananda Naik died at the spot. I was examined by the police in the case. I also made statement before the JMHC Digapandi regarding the case matter. Exhibit 26 is my said statement, wherein my signature is 26/1 and MO2 already marked the said condition.
No, this witness has also excluded the three co-accused persons who have participated in the assault of the deceased. So, number one is that the corresponding injuries are not there. Number two, one of the eyewitnesses has excluded the three co-accused persons. So that was the reason why the
three accused
persons acquitted. But so far as you are concerned,
that was this appellant was injured by the deceased. That appellant was
assaulted by the deceased.
ठीक होला.
Again you come. Rather, his son was assaulted by.
The deceased assaulted this appellant with a stick.
He don't care. Ananda Naik by means of immediately thereafter accused Chitra Naik assaulted. I found Ananda Naik assaulted accused Chitra Naik by means of a jaggedly bed stick on his head. Immediately thereafter, accused Chitra Naik assaulted Ananda Naik by means of medicine.
But Ananda, as a deceased assaulted as apparent by jaggedly body on his head, immediately thereafter accused.
But is it a private defense?
What about the injury sustained by the
PW1 is stated.
Doctor who examined that appellant.
PW1.
Dr. Raman Patnaik.
That Chayaram Raman is
So there was a scalp achieved, lacerated wound, then
Scalp death on the
right
contusion.
So the injuries are simple in nature, but one on the head and the other is on the right supraclavicular region. No specific plea has been taken regarding right of private defense.
Yes, 313 question.
Fine.
Relevant is 51.
51.
Yeah, last.
अच्छा
ନାଇଁ ମିଛ କଥା ଆନନ୍ଦ ଆସି ମତେ ଆଗ ଠେଙ୍ଗାରେ ମୋ ମୁଣ୍ଡକୁ ମାଇଲା ମୁଁ ତଳେ ପଡିଗଲି ଏଇ ବିଷୟରେ ପ୍ରମୋଦ ଆସି ମୋ ହାତରୁ ବଡି କାଟି ଛଡେଇ ନେଇଗଲା ବେଳେ ଆନନ୍ଦ ଛାତିରେ ଉପରେ
so let us say that since it is your witness that PW10
yes
so that witness has stated that it is the deceased who first began the assault. And of course, the corresponding injuries are also there on the vital part of the body. But again, it would depend that whether how far you can go to exercise private
PW10 is turned hostile. Turned hostile. At para 4 months.
PW10.
Yes.
Sorana.
Page 18. It is a fact that I have been examined by the police in this case.
Yeah.
It is a fact that I have stated with the police that while deceased Anand Naik was going to save his son Pramod from the clutches of the accused person, accused Chittara Naik assaulted him on his head by means of a Godisa part, and thereafter deceased Anand Naik assaulted the accused Chittara Naik by means of Jagoli body on his head. Totally turned.
No, it's all right.
No. But there is admittedly some injuries.
Good. ना ये part था
नहीं ऐसे फाट कहले ना ये फाट पड़ेला बोली चित्त आनंद
और पुलिस पाखे
पुलिस पाखे कहले जे
आनंद सेकेंड रे मारला माने डिसीज तापरे मारला जे तार माड़ा हेई सैला परे मारला but that evidence is there in chief examination it is there that and it is coupled with the medical evidence. Now गोटे पर्टिकुलर पार्ट रे गोटे होस्टाइल विटनेस हेजिवो बेली तो लॉ टा होची एंटायर एविडेंस को हमें डिस्कार्ड कर दबनी तेणु एई पार्ट रे गोटे पार्ट रे जदी ये हला ताले या एविडेंस जो आसुची जे during the course of occurrence let us go to that extent during the course of occurrence the deceased had assaulted the appellant एई पार्ट टा आपन को आसुची ना नाही आगो पछ हमें जीवा पड़ এই পার্টটা আসুচি coupled with the fact that the appellant has also sustained two injuries one on the head and the other on the so that part is also the and he was sent notice injuries were noticed immediately and sent on police requisition PW1 evidence hochi police requisition ତେଣୁ ଏଇ PW1 ତେଣୁ ଏଠି ଯଦି ଏଇଆ evidence ଆସିଲା ଆପଣଙ୍କର it may be that you may say that he has exceeded the right of private defense जे से simple injuries करथिला बा a type रो ताकू ये that argument you can advance but how can it be if that would be the how can it be a case under section 302 exceeded right of private ଆପଣ ଆଣିଛନ୍ତି decision somebody has exceeded the right of private पॉइंट जीवा कथा आपण माने हमें घर भी होल्ड करिबो जे राइट ऑफ प्राइवेट डिफेंस भी एक्सीड
करी
ताले 302 हबनी ए माने 301 तापरे कोन आपण डिसीजन लेसर ऑफेंस रा
नहीं करिवे जे आपण देखियो जेठी ना से ना नहीं इट इज जो
दीटा जिंस कथा प्लीज लिसन टू माय स्किन द हार्डी
गडिसा जोटा देल मारला सेटा आगे हेड रे तापर पियर्स कला बेली रे
yes
से जो बाहर पे पुनी पियर्स करते हो बोले सो दिस इज द टू थिंग दैट यू हैव टू सी व्हेन यू आर सर्चिंग ए डिसीजन सो इट इज नॉट इन दिस
304 पार्ट 1 रे इंटेंशन दरकार सो एठी इंटेंशन आपण जदी जो पार्ट आपण सिलेक्ट करूछंदी सेठी जदी इंटेंशन आसीबो नाउ द क्वेश्चन इज दैट इफ यू हैव एक्सरसाइज्ड exceeded the right of private defense and your intention is there that what would be the offense that is it right step IPC. Exception 1 टा होची when the culpable homicide is not murder. Culpable homicide is not murder if the offender, while is deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident. The above exception is subject to the following provisions: that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to the person, that the provocation is not given by anything done in obedience to the law or by a public servant and in the lawful exercise of the powers of such person, that the provocation is not given by anything done in the lawful exercise of the right of private defense, whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact. ତେଣୁ ଏଠି ଯଦି if this court accepts that during that uh, uh, occurrence the assault was made to the appellant by the deceased, and it is not one as a blow, it is two blows because the parts of the body are different. So two blows have been given, and your prosecution witness has stated the IO has seen the injuries and sent him on police requisition for examination, and the prosecution, the doctor has also noticed two injuries. So there is possibility that after receiving the injuries he might have reacted, might have been provoked. But the question is that to what extent he could have exercised his ତେଣୁ ଏଠି ଯୋଉ ଟାଇପ ର ଫ୍ଲୋ ଆପଣ ଦେଇଛନ୍ତି ତାକୁ ଯାହା ଆପଣଙ୍କୁ ପଏଣ୍ଟ ଆଉଟ୍ କରାଗଲା ଯେ ଆପଣ ଯୋଉ ଦିଟା ଫ୍ଲୋ ଦେଇଛନ୍ତି, so whether you are within the right of private defense or if you are exceeded the right of private defense, if we come to a finding that you have exceeded the right of private defense, then what will happen in the case? If your case covers under exception 1, then what would be the offense, whether it would be 304 part 1 or part 2, ହେଲା ତେଣୁ intention ଟା ଆପଣ ଯୋଉ part of the body select କରୁଛନ୍ତି ତା ଦେହରୁ ଆପଣଙ୍କର intention ଟା ପଳେଇ ଆସୁଛି, କାରଣ you see again the doctor's evidence, that is doctor is PW2 na. Yes. Punctured star wound on the swan sword corresponding to stump. ଏଠି ଆସିଲ ଏଠି on the sword smart. They can say that the exceeded. exceeded right of private defense. Uh, 304 Part 1. Part 1. IT. I.P.C. Intermark. Whether the offense can be convicted for having exceeded the right of privacy. In instant case where in line to work, the appellant had necessarily acted in exercising the right of privacy. So the appellant later necessarily passive. Because we found that three of the appellants are equal. Same instant, two of the appellants were in the vital part of the document. Not to be fatal because it is what we found is the structure of this fog. But is our apparent fact that fault on them was not directed on the non-vital part of the body, but directed on the vital part of the body. Such as in these circumstances, it is reasonable to infer that the offense entertained in classification that appears to previous in the consequence of such assault. Thereof, right of defense, therefore extended to voluntary public offense. Yes, therefore concluded that the offense should proceed managed that the law code 28 and on how it held that book one that a right of private defense is certainly exceeded the right as much as the facts and circumstances that all justify the in upon in such a manner as to cause the death of someone is therefore the activity of the offense part 1. So the order of the response to the convicted in under section 2 because further that we do not find this case to be one that has justified in reversing the finding recorded by the trial court. That will become the complete taken by the High Court is also reasonable. Whereas once we agree the finding of the trial court that he has exceeded the right of privacy pursuant to pricing from there is no justification for reaching on such a man to call the death of the deceased, therefore held in guilty under footnote of part 1. So, are exceeded on. And previous some of the judges to have found the person concerned simple absence of the on the actual so that he had right of on the extent of firing 6 times and killing 1 person, 6 of it, simply exceeded right of firing. And on the funds of the land of the sons. That's it. Trial for the plan to convict part such a part of and sentence from and put them and exhibit on part on the confirm. So, Mr. Mahanti and Mr. Tripathi, you can find many a decision on this point that wherever it has been held that the accused has been assaulted by the deceased, but the injuries are simple in nature, not that grievous. But he has exercised his right, he has assaulted the deceased and caused the death. So, in most of those cases, it has been held that he has exceeded his right of private defense, and therefore they have come to the conclusion that it would be a case under section 304 part 1. So that is relying on that exception 1. Most of the cases. So here, if we believe that part, it is your witness. So, it has been. They exceeded the right private position responsible. They are liable to be considered finding of the court below. Then finding. we will now take up the incident that took place in the dispute and the High Court with regard to the having come to the conclusion the possession of the dispute and the appellant and the appellant had exceeded the right of private defense to the extent of protecting the property of which he was in possession, but after examining the evidence of the came to the conclusion that the appellant Guardian are concerned they have exceeded their right and are liable to be punished under 3 group part 1 for having committed the murder of accused Vivaldians. Finding on the High Court Committee evidence in cases which are discussed by the High Court and it's clear that the applicant had attacked on one even after he had fallen down on the ground with cover. Dr. Swans of PW20 evidence as the prosecution stated that rape of funds was the consequence of two head injuries that resulted in fracture of parietal and occipital bone, and these injuries were sufficiently not in the force of psychological death. And from the evidence of the prosecution, I could have rightly come to the conclusion that two were held by the appellant, but by exercising their right of power at the same time, I could not have justified in coming and complete the act of these two persons, namely Swan so came under exception Swan so amounted to homicide not amounting to murder because the same is known in exercise of Swan so. And but the part 1 proceeding set aside the conviction on the 3 group construct. So, no, what we find, Mr. Tripathi and Mr. that you have adduced the evidence of 2 eyewitnesses. So there are material discrepancies between the 2 eyewitnesses because one has implicated, apart from the appellant, 3 others participated and assaulted also, which is not the case of the other eyewitness. And there are no injuries and they have been acquitted. So in that way, you can say that the clear picture has been not brought on record as to whether those persons who are present, who is speaking. This is your 2 witnesses. Who is speaking truth? Whether it is PW 15. So that is one aspect. The number 2 aspect, that if your witness has stated that there was an assault made to the appellant by the deceased, maybe that after or previous, but that at least your witness has stated in the chief examination that it was prior to the assault. So he was assaulted, and this the witness PW10, PW10 has stated that at that time the deceased was coming with his son. I found the deceased assaulted the accused by means of Jagili body on his head. I found that the accused Chitra Nayak assaulted Ananda Nayak by means of Gadia. So the assault has been attributed to first to the deceased, and after the arrest on the very day, this the appellant on 22/8/2003 itself, he was examined by the doctor, and the lacerated wound was found on the scalp and the other injuries on the right supraclavicular region. So some kind of assault, some kind of provocation on the part is there, But if you say that he has exceeded it, he should not have assaulted on those particular parts. And so whether it comes to the exceeding of the right of private defense or not, if it is exceeded, then that has been taken into account exception in number of cases. At least we have found 3 of them, that it is 304 part 1.
Yes.
So, what do you say? What is your investigation?
Also 1976 court, where the prosecution had specified the injuries to that, but for consequence.
That Lakshmi Singh was. They have stated that you are suppressing a part of it, not correctly. In a murder case, non-explanation of injuries sustained by accused at about the time of occurrence or in the course of altercation is a very important circumstance from which the court can draw the following inference: that the prosecution has suppressed the genesis and the origin of the occurrence and has not presented the true version, that the witnesses who have denied the presence of the injuries on the person of the accused are lying on the most material point, and therefore their evidence is unreliable. That in case there is a defense version which explains the injuries on the person of the accused, it is if it is rendered probable so as to throw doubt on the prosecution case, the omission on the part of the prosecution to explain the injuries on the person the accused assumes much greater importance where the evidence consists of so and so.
But here the medical evidence has been produced. Prosecution has adduced evidence on through doctor that there is an injury on the.
Not only that, they have also examined
They have
one
also
witness.
examined witness.
Number 2, ଆପଣଙ୍କର ଯୋଉ ଡିଫେନ୍ସ ପ୍ଲିଟା ହଉଛି ନା, ଯେମିତି କଣ ନେଇଗଲା ବେଳକୁ ତା ପେଟରେ ପଶି ଯାଇଥିଲା, then it cannot be accepted because there is an injury on the head. ଆପଣ ଆସୁନାହାନ୍ତି ଆଉ ଥରେ ସେଇ ପାର୍ଟ କୁ ପଳେଇ
ନାଇଁ ନାଇଁ ଗଡିସାଟା ଗଡିଗଲା ପରେ ଟୁନି ଇଏରେ ପଡିଗଲେ
ଆପଣଙ୍କର ସେଇ ଯୋଉ ପାର୍ଟଟା କହିଲେ ମିଷ୍ଟର ତ୍ରିପାଠୀ ପ୍ଲେସ୍ କରୁଥିଲେ ପରା କେସ୍ 51 ରୁ ଆନନ୍ଦ ଆସି ମତେ ଆଗ ଠେଙ୍ଗାରେ ମୋ ମୁଣ୍ଡକୁ ମାଇଲା, ଠିକ ଅଛି, ମୁଁ ତଳେ ପଡିଗଲି। ଏଇ ସମୟରେ ପ୍ରମୋଦ ଆସି ମୋ ହାତରୁ ଘଡିସାଟି ଛଡାଇ ନେଲା ବେଳେ ଆନନ୍ଦ ଛାତିରେ ଗଳି। ତ ଏଗେନ୍ ଛାତିରେ ଗଳିଗଲା, ତାହେଲେ ସେଇ ଯୋଉ ଆର ଇଞ୍ଜୁରିଟା କୁଆଡେ ଗଲା? ଆପଣ ଏକ୍ସପ୍ଲେନ, ଆପଣ ସେଇଟା କଣ କହୁଛନ୍ତି? ଯୋଉ ଡିଫେନ୍ସ ପ୍ଲିଟା ଏମିତି ପ୍ରୋବାବୁଲ ଯଦି ହେଇଥିବ ଯୋଉଟା କି ଏକ୍ସପ୍ଲେନ କରୁଥିବ ମାନେ ତାଙ୍କର ଇଞ୍ଜୁରି, ଡିସିଜ୍ଡ ଇଞ୍ଜୁରି ହେଲା, ଫାର୍ଷ୍ଟ ଜିନିଷ ହଉଛି ଆପଣ ସେମାନେ ଆକ୍ୟୁଜ୍ଡ ର ଇଞ୍ଜୁରି ବିଷୟରେ କିଛି ଏକ୍ସପ୍ଲେନ କରୁନଥିବେ, ନମ୍ବର 1। ନମ୍ବର 2, ଆପଣ ଗୋଟେ ଡିଫେନ୍ସ ପ୍ଲି ଆଣୁଥିବେ ଯୋଉଟା କି ମାନେ ପ୍ରସିକ୍ୟୁସନ ର ଅର୍ଥାତ ଡିସିଜ୍ଡ ର ଇଞ୍ଜୁରି କୁ ଏକ୍ସପ୍ଲେନ କରୁଥିବ ଇନକ୍ଲୁଡିଂ ୟୋର୍ସ ହେଲା। ତା ଛଡା ଯଦି ଇଞ୍ଜୁରି ମଧ୍ୟ କୋଉ ଟାଇପ ର ହେଇଥିବ, ମାନେ ସେ ତା ଦେହରେ କହୁଛନ୍ତି ଯେ ଇଞ୍ଜୁରିଟା ଏଠି ଦେଖନ୍ତୁ, the principles obviously would apply to the cases where the injury sustained by the accused are minor or superficial or where the एटी जदि एटा would not obviously not टा छड़ाई जोठी minor injury हेतिबो बा superficial injury हेतिबो बा जोठी evidence टा clear present हेतिबो independent हेतिबो सेठी ए जो material एटा omission को धरा जीवन। तेणु जदि आपनकर superficial injury हेतिबो possibility दा आपन कोडी accused पड़ जाइतो हुए तो से जिंस notice miss कर जाइतिबो माने आई विटनेसेस माने तेणु आई विटनेस कोई जीवन जे समाने suppress करूछन, किंतु जदि हाँ मेजर पार्ट रे हला इट इज नहीं एठी इंजुरी अछि, एठी इंजुरी अछि,
रिक्वेशन जाइछि,
एठी इंजुरी अछि, even though eyewitnesses have not stated anything, but one of the prosecution witness has come forward to say that this way you receive the injury. तेणु से पार्टा आसुची, but again आपण जो डिफेंस प्लीटा नहीं चंती, that is not explaining the injury sustained by the deceased, कारण आपण कहले पॉसिबल आई है
one is head that was PW2 has cross-examination said the person in contact with an fall or floating object that may be caught very and another injury if he fell down then the chance of piercing the body.
ନାଇଁ ନାଇଁ ବର୍ଷା ସେଠି ଆସିବ କୋଉଠି ସେ ପିୟର୍ସ ହବ
ସେ ଘୋଷାଡ଼ି ନେଇଥିଲା ବୋଲି ସେ ତାର ସ୍ପେସିଫିକ ଇଏଟା ତା ଭାଇ
ଆପଣ ଯୋଉ ଇଏ ବି ନେଇଛନ୍ତି ଷ୍ଟାଣ୍ଡ ନେଇଛନ୍ତି ଏବଂ ଯୋଉ କନଫ୍ରଣ୍ଟ କରିଛନ୍ତି ନା ଦିଟା ୱିଟନେସ୍ କୁ ଯୋଉ you please come to the evidence of this PW15 who is one of the eyewitness. Come to paragraph number 6 page 93. ଆପଣ ସେଇ plea ହିଁ ନେଇଛନ୍ତି. It's not a fact that Pramod tried to snatch away MO2 from Chitra Nayak which he attempted to assault to the deceased when he attempted to assault the deceased, and while he was snatching the same pierced on the belly of the deceased, for which the Pramod fled away leaving the swan soul. এইটা হচ্ছে গোটে সাক্ষী ହେଲା আই উইটনেস ହେଲା PW15 আର আই উইটনেস ଟା ହେଲା PW9 PW9 ର ମଧ୍ୟ ଆପଣ এটা ধরলাম সে টাইপ ର ପ୍ଲି ନିଆ ହେଇଛି ଏଟା ଖାଲି କୁହାଯାଇଛି ପଲିଟିକାଲ ହସ୍ଟିଲିଟି ପାଇଁ ଇଏ କରାଯାଇଛି.
para 15
କଣଟା
ସେ କହୁଛି ଯୋଉ ପଶିଗଲା
କୋଉଟା କହିଲେ
para 15
କାହାର ଏଭିଡେନ୍ସ
ଏଟା PW9
PW
when the accused persons came near our house on the date of occurrence, my father was not there, as he had been to watch the field. I have not seen. It's not a fact that my father assaulted accused Chitranak on his head by means of Jagali body, causing severe injury. It is not a fact.
Mr. Tripathi,
yes,
what the Supreme Court says in the decision which he has produced, that if it is a minor and superficial injury, then prosecution need not explain the same. And even if it is not explained, it cannot be a serious lacuna in the prosecution case. But one thing you remain, that simple injuries are not minor injuries. Because grievous injuries have been defined under section 320. So, if an injury can be caused on the vital part of the body, so but if it would not come within that 8 exceptions, that 8 clauses, তাহলে সেটা হয়তো grievous না হই পারে কিন্তু it cannot be said that minor in nature, simple injury. ତେଣୁ ସେଇ ଯୋଉ 8ଟା ରହିଛି 320 ରେ ସେଥିପାଇଁ ସେମାନେ deliberately use word କରିଛନ୍ତି minor and superficial. Emasculation, first, second, permanent privation of either eye, permanent privation of the hearing of the either ear, privation of any member or joint, destruction, permanent impairing of the powers of the joint, then permanent disfiguration of the head, face, fracture, dislocation of bone or tooth, then any hurt which endangers life or which causes the sufferer to be during a space of 20 days in severe bodily pain, unable to follow the. So, এই ভিতরে আসলে হি যাইকিনি grievous injury হবে. So, otherwise, but if it is on the head part, so if this does not attract any of those clauses, so obviously it cannot be a grievous injury. But it cannot be said to be a minor or superficial because so in this light you both of you we can take up this matter tomorrow. We'll take up this matter tomorrow. Guru Adelaide. All right. You have placed the decision. It's all right. You're keeping note of it and set down the decision. Is one. କାରଣ ସେଇଥିପାଇଁ ଡିସିସନ୍ସ ଗୁଡାକ ଅଛି ଯେ ଗୋଲ୍ଡେନ ସ୍କେଲ ରେ ମପା ଯାଇ ପାରିବନି ଆପଣ କେତିକିଟା ଇଞ୍ଜୁରି କରିବେ ସିଏ ଏତିକିଟା ମତେ ମାଇଲା ମୁଁ ସେଠିକି ଇଏ କରିବି ଗ୍ରେଭ୍ ସଡନ ପ୍ରୋଭୋକେସନ ହେଇଗଲା ମାନେ ଆପଣ ଆସଲ୍ଟ ହେଇଗଲା ମାନେ ଆପଣ କଣ ଆଣ୍ଟିସିପେଟ କରିବେ it is very difficult that ମୁଣ୍ଡରେ ମାଡ ହେଇଗଲା ଇଏ ହେଇଗଲା ସିଏ ତା ହାତରେ ଏଇଟା ଅଛି ସେ ମତେ ଫର୍ଦର ଇଏ କରିବ ତେଣୁ ମୁଁ ରିଆକ୍ଟ କରିବା ଦରକାର ମତେ ନିଜେ ସେଭ୍ କରିବା ପାଇଁ ତେଣୁ ସେଟାକୁ ଏତେ ରେଷ୍ଟ୍ରିକ୍ସନ ଭିତରେ ଗୋଲ୍ଡେନ ସ୍କେଲରେ ତାକୁ ଇଏ କରିବା ଉଚିତ ନାହିଁ ଯଦି ଟିକେ ବି ଏକ୍ସିଡ କରିଛି ତାହେଲେ ଇଟ୍ସ ଅଲ୍ ରାଇଟ୍ ଇଟ୍ ଇଜ ୱିଦିନ୍ ବଟ୍ ଯଦି ବେଶୀ ଏକ୍ସଟ୍ରିମଲି ଦେନ୍ question comes of that 304 part 1 thing right so we'll take up this matter day after a coordinate document.
Minimum is 14 again conviction on 673 IPC RA 10 years in purpose is 14 both is kind of similar
My note is mentioned is for date and out of previous industry for Madam, there is another mention for professional.
You adjust your band, it's not proper. Okay.
Very satisfaction. Is not sweater that has been convicted a lady inside of that is the criminal appeal number 1322 of 2002. 1322.
May I be permitted to make a mention, Milords?
Yes.
Milords, though supposed to be a fresh admission, the Lordship remembers that matter where the Vigilance Council made a false statement and it was urgent. Then went out of list due to that election case. Criminal revision number 356 of 23. It has never been heard.
All right. Number 20. Yes.
356 of 2023.
We have noted down.
Oblige, Milords.
Special notice for delivery of order CRLA 252 of 23.
Therefore, I am of the humble view that for the limited purpose of ascertaining whether the stay of order of conviction be granted or not, I find that the petitioner has failed to make out a very exceptional case or special reasons for keeping the conviction in abeyance, and as such, in the facts and circumstances of the case, the relief sought for by the petitioner for staying the order of conviction cannot be granted. Accordingly, the interim application being devoid of merits stands dismissed. Yes.
Petitioner is the wife of the appellant Miller. Appellant died on 3/12/2019. My lord, wife has filed in IA for granting leave to continue the criminal office by the vigilance.
What is the delay pointed out by the
Delay, my lord. Delay, my lord. Due to mentally depressed.
when the death took place? 3/12/2019. So you are supposed to file within 30 days.
Yes, my lord.
And you filed it in 2023. So, yes. He has not served a copy on you.
I have already served my lord. The copy with me receipt.
Whether it is Mr. Sanjay Kumar Das or you are to argue. Okay. So, the name of Mr. Das be deleted from the call list and Mrs. Tripaঠি's name will be reflected. The Learning Council for the Vigilance Department submits that she has not yet received the copies of the interim applications from the Learning Council for the appellant. Let the Learning Council for the appellant supply the copy of IA number 2863 of 2023 and 2864 of 2020. The Learning Council for the Vigilance Department. During course of this week.
I have already solved the
copy during course of this week, put up this matter. Next week, instructions shall be obtained on the interim application. In the meantime, yes. Okay. You are moving the first one, 37 of 2017.
Since 27/9/2013.
27/9/2013. Yes. You have never been released on interim bail.
I have released interim bail for a period of 4 times. In IA number 67 of 2020, I had ordered a 60.
No, now what is your custody period? Have you obtained the custody certificate?
Never supplied, but your see the.
Yes, have you obtained the custody certificate? Item number 2, CRLA number. The first one is 37. You bring. Also bring because they may file also. You bring not only the custody certificate of Devraj Badi, but also the other appellants in the connected.
They have never surrendered the court below. In this
CRLA number 37 of 2017, the Learning Council for the state takes some time to obtain the custody certificate of the appellant. Put up this matter, give a date. Yes, next year. Yes. Okay. So this next.
Now we get both.
Next.
Item 4.
After 10 years conviction, 8 years, 6 months.
Well, how can I know? What is the custody certificate?
So they are granted interim bail by your at that time your option they have instead custody then 6 years 6 months.
Which order?
Order is your order dated 1/11/2021 and the phone divos over.
Sentence is 10 years. Yes, Mr. Tripathi, part the Learned Counsel for the petitioner and counsel for the state. Considering the submission made by the Learned Counsel to the petitioner. ଏଟା କଣ କେତେ ଜଣ appellant?
3 ଜଣ appellant ଥିଲେ ଜଣେ interim bail ଯାଇଥିଲା
No, this 1168 has been filed by whom? It is mentioned that petitioners. No, that's not one. Jane jaichi bail jedi apono
current settlement file.
So now everybody is in custody. All the three appellants.
Current settlement file. Or this is 65 currently.
The report is that the two appellants, Gauri Maji and Bhagapati Naik, they did not avail the benefit of interim bail order. And the other appellant, that is appellant number 1, Pagleshwar Das, he availed and surrendered after the considering the submission made by the Learned Counsel for the appellants that they are in judicial custody for more than 8 years out of 10 years of substantive sentence imposed on them by the Learned Trial. And there is no chance of hearing the appeal in the near future. And people has not been prepared. And taking into account the conduct of the appellant number 1, availed the interim bail order earlier and surrender at right time. And the fact that the other two appellants have not availed the interim bail order after hearing the Land Counsel for the case. I'm inclined to, I'm keeping in view the ratio let down in the case of Mohammed Muslim. So bail is allowed.
There is this
What is that?
there is bail for 3 months.
CRLA number 2000 to the matter as
I put the appellant in that case. But appellant is not available.
Did you make that 225 day? Let us call for the instruction. Item number the 4 Rasul sub item CRLA number 225 of 2018 Narayan Barik is the appellant. The Learned Counsel for the appellant submitted that even though the petitioner was granted interim bail for a period of 3 months as per order dated 28/2/2023 in IL number 2144 of 2023. But he has instruction that the appellant has not availed the same. In view of such submission, let a report be called for from the Learned Trial Court, that is Additional Session Judge cum Special Judge Navrampur in city case number 73 of 2015 bracket T as to whether the petitioner availed the aforesaid interim bail order or not. Put of this matter immediately after the report is received from the Learned Trial. Yes.
Item 9.
It's a bail application, there is no interim there. Oh, that is Lekhaji bail bill. Is it an application for interim bail on the ground of somebody's ailment? Kahar ailment is? Huh? Come to your petition, let us see. Where have you mentioned?
I am on 2491
Yes.
So why not the petition is seriously one man, more studies. And she requires better treatment and care, and as there is the lower to move up to one petition and it's on.
What instruction you have received? IA number 2491 of 2023. The Land Council for the state submitted that instruction has already been sought for on the IA and he is yet to receive the same. And the matter may be taken up next week's put of this matter in the week commencing from 18th December 2020.
Item 6.
From 10 years, out of it, from 80. 8 years, 4 months.
What could you say?
Interval, order dated 21/6/2023.
21/6/2023.
Interval.
So that I have granted you interim bail on for 3 months.
3 months.
Where is the surrender certificate?
I already filed. This is the copy also. There is copy also. I copy.
Yes, Mr. Part the Land and Council for the petition Land Council for the state. Considering the submission that the Land Council for the petitioner that out of 10 years of sentence imposed by the Land Tribunal, the petitioner has already undergone sentence of more than 8 years and traveling the interim bail period, he surrendered at right time and there is no chance of early hearing of the appeal even though the paperwork has been prepared. After hearing the Land Council for the state keeping the receiver down in Swansea, bail application is allowed.
Item 7.
My lord, here the appellant I am appealing
Item 10.
In this case, the applicant custody more than 50% of the sentence.
Surrender certificate.
Surrender certificate matter already filed. There are 4 appeals. Surrender certificate and copy, giving the Xerox copy of the order. Original certificate copy in connected Kindle object rather than private copy. Original connected certificate I-38/2008. This is the Xerox copy. Next page subject order Korea case ଅଛି. Next page ସମସ୍ତଙ୍କର କଷ୍ଟ ଅଛି. Convicts namely Bonmari Jadhav, Rajkishore, Jayasekhar and Sectional Court. Convicts are taken from.
That already.
15 years condition. The appellants have remained in custody 7 years 10 months. Out of 7 years 10 months, they have an interval for a period of 3 months. So 7 years 7 months. More than 50% of the sentence. I will surrender in right time.
Wait. That is sentence is 15 years. Yes. And where is the custody certificate? No. Custody certificate and
Only directed in the high number release 3 months.
bring it, will take up next month. Give the name of the jail that
All the conditions provided.
All right. CRL number 82 of 2019. The Learned Council for the appellant has produced the surrender certificate of the appellants, who also the co-accused persons, who are the appellants in the connected criminal appeals, which is taken on record. It is the contention of the Learned Council for both the parties that out of 15 years of substantive sentence imposed by the Learned Trial Court on the each of the appellant has already undergone half of the sentence. Let the Learned Council for the state produce the surrender custody certificate of the appellants Dayasagar Yadav and appellants Rajkishore alias Rajkumar Yadav, Bonmar Yadav and Shekhar Prasad Yadav of the connected appeals. This matter along with so and so we commencing from 18th. The copy of the order be handed over. Peter of the one. Pavitra Kumar Paik. Yes, next.
Item 12.
That is 10 for 10 years. Under 10 years,
No, when you are granted interim bail. So where is the surrender certificate? Sentence is 10 years. And you have undergone?
More than 7 years.
So where is that surrender certificate?
Already surrendered and filed.
Okay. This is item number 12. You can copy over the prisoner's petition as she.
Yes.
So, but Babita Sahu's name is to be deleted. You have filed your Vinama?
Yes.
Okay, previously the prisoner's petition received at Flagi to engage Mr. Jugar Kishore Rao. The London Council की वकालतनामा तो देखिए जुगर किशोर राव का मिस्टर महादेव the London Council to Jugar Kishore Rao and S.K. Mahanti have filed wakalatnama. The name of Ms. Babita Sahu shall not be reflected in the first instance for sub-para. Mr. Mahanti submitted that after availing the interim bail period as per order dated 14 to 2023, passed in IA number 453 of 2019, the appellant has surrendered before the London trial court, and he may be given some time to produce the surrender certificate. Next week, please, this matter will be commencing from 18th of December 2020. Yes.
Item 13.
We can check the custody since for 2015. I have calculated 3 times he has been granted interim bail. Now the custody period is 7 years, 11 months.
Right.
That is my lord, I have.
Your
lordship can see the last one. Custody period.
Custody certificate achi.
Your lordship, by granting bail, free bail, also calculated.
London Council for the appellant submitted that out of 10 years of substantive sentence, 12 years of substantive sentence, he has instruction that the appellant has already undergone sentence of more than 7 years.
7 years, 11 months. After deducting 9 months.
11 years and 11 months. London Council for the state produced the custody certificate. Jail kotha koyni. Of this matter on 18th of December 2020. Yes.
Certificate already filed.
Thank you.
That is on
No,
31st day 2020.
for the submitted surrender certificate is already filed. Yes, that is there. I see.
Okay.
Your Lordship, in item number 11, due to some personal difficulty, I am traveling to somewhere, so I am running to Your Lordship. And it's getting problem to get into that video, Your Lordship. Item 11, Your Lordship.
Kuade jauchandi?
Your Lordship, I am going to Visakhapatnam. I mean running train, Your Lordship. I am apologize for that.
ସେଠି ପହଞ୍ଚି ସାରନ୍ତୁ ଯେତେବେଳେ ପହଞ୍ଚିବେ ଫୋନ କରିବେ.
Oblige, Your Lordship.
Item 14.
May I please, Your Lordship? This is a case, my lord. The appellant earlier approached before this honorable court in criminal appeal number 17/17. Here is a case, my lord. This matter is
Just a minute. Okay, the delay in filing the CRLA that has been condoned.
condoned. Delay order condoned.
What is the CRLA for? What is
CRLA
the
17/17. Earlier disposal.
No, What are you challenging in this CRLA?
This is the case, my lord. The application for release of a vehicle. And I am challenging Annex 2.
All right, you obtain instruction in the matter.
Kindly have last minute. And in the rejection order, clearly mentioned, my lord, attachment has been absolute on section 9(6) of the Act. He has not raised there any question, my lord, before the trial court. In the meter, that has absolute on 26/11/18.
That order he is challenging here. So since an appeal lies against the influence order, so he has preferred the appeal. It is to be decided as to whether the absolute order is sustainable in the eye of law or not. So the learned counsel for the Mr. Patra, learned counsel appearing for the state of Orissa in OPID Act matter, special counsel, seek some time to obtain instruction in the CRLA. Let an extra copy of the appeal memo be served on the Mr. Patra during course of this week, put up this matter in the second week of January 2024. Yes.
My lord.
Item
15 years. ହଁ ଆସିବ ରିପୋର୍ଟ ଆସିଲେ ତ ଆପଣ ଆଣିଲେନି କଣ କରାଯିବ? ସେମାନେ କେମିତି ସବୁ ଆଣିଲେ? କ୍ଲାଏଣ୍ଟକୁ ଯେତେ ଢିଲା ଦେବେ ସେମାନେ ଆହୁରି ଢିଲା ହେଇଯିବେ। ତେଣୁ ସଫର କରିଯିବେ କ୍ଲାଏଣ୍ଟ କଣ କରାଯିବ? ସେମାନେ ତିନିଟା ବେଲ୍ ହେଇଗଲା ତାପରେ ଆପଣ କ୍ଲାଏଣ୍ଟ ଆପଣଙ୍କୁ ପଚାରିବ ଯେ ସେମାନଙ୍କୁ ବେଲ୍ ହେଇଗଲା ଆପଣ କଣ ପାଇଁ आइटम नंबर 16 कौन होगा? मैं डॉक्यूमेंट दीजिए से जो आरब वाला अब वेरीफाई करना है देखो the London Council for the state submitted that recently he has received the name, address and documents of one local surety, namely the नाटा कौन एबे जी अभिमन्यु गौड़ एबे जोड़ा दीजिए अभिमन्यु गौड़ and he is yet to receive instruction about the authenticity of the documents and also the genuineness of the bailers and bailer and the willingness to take the petitioner the appellant on bail. Appellants on bail, huh? Put up this matter. Give it. Yes. Next.
Petitioner number 1 completed half of the sentence. Complaint for 10 years and filed the converse. And in the meantime, two successive IA have been filed and he has been released on bail initially by university.
What is the custody certificate?
I have filed
Flag? Fine.
yes,
Copy je do na ji?
yes, I have an
Pass on. এটা সরেন্ডর সার্টিফিকেট এটা ମୁଁ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ମାଗୁଛି ଟୋଟାଲ କେତେ ପିରିୟଡ ରହିଛନ୍ତି already obtained that custody certificate. The London Council for the Appellant submits that what is the sentence imposed?
10 years plus.
Out of 10 years of affirmative sentence imposed by the London Trial Court, the appellant has already undergone half of the sentence, half of the substantive sentence.
Order one there
I didn't bring it. So मझिरे जाइछन्ति केते कोन ହେଇछि तो हिसाब हो the put of this matter the commencing on such and such date. Custody certificates are be produced by the Land Council for this state. Yes. ওকালতনামাটা তো এটি এটা রবীন্দ্র মার্থা লেখা ହେଇଛି ନୟାଗଡ଼ ବୋଲି ତାପରେ ପଳେଇଲାଣି no the jail where the signature in the wakalatnama was taken that is sub jail Nayagad.
Which time lordship you are there?
Acha. All right. Next.
Item 18.
The sentence was for 10 years, out of which my lord gets on my lord 6 years and 5 months and 13 days. He is a volunteer person of 66 right now, my lord, because they were on bail.
Certificate and change.
3 months ପାଇଁ ସେ ଯାଇଥିଲା
Custody certificate ଟା ଦିଅନ୍ତୁ କେତେ ବର୍ଷ
ସେ କେବେ bail ରେ ଯାଇନଥିଲା ସେ 2017 ରୁ କି decide custody ନାହିଁ 26/7/2017 ହିଁ custody ଥିଲା ଖାଲି 3 ମାସ ପାଇଁ ବାହାର ଥିଲା 19/12/2022 ରେ in IN number 281/22 by Honorable Justice Shashina Mishra. 3 ମାସ ପରେ ସେ ପୁଣି surrender କରିଛି 2917 IN ରେ ଗୋଟେ ଫାଇଲ କରିଛି bail ରେ ତାର last page ରେ surrender certificate ଅଛି 21/81 ରେ ବାହାର ଥିଲା 3 ମାସ surrender କଲା ସେ certificate 2917 ଅଛି last page.
See, from the judgment, it doesn't appear when you are taken into custody. So it should have been there. In the first page, in custody खाली लिखा है कि केबे to custody लिखा है. The Learning Council for the appellant submit that out of 10 years of substantive content, the appellant has already on more than 6 years of sentence. Custody certificate is produced. Yes.
Item 19. Item 25.
ଆପଣଙ୍କର କୋଉ ଆପ୍ଲିକେସନ ନମ୍ବରଟା କେତେ? ଇଣ୍ଟରିମ୍ ବେଲ୍ ମାଗିଛନ୍ତି କଣ ପାଇଁ? ଇନଷ୍ଟ୍ରକ୍ସନ ଆସିଲା।
He is staying the outside my lord. Several letters have been communicated to the doctor of hospital also my lord, and to the IAC also, but not yet received any information
ये
from
बाहर लोग तो
IAC.
टूट गया।
Yeah. Sir, I would actually be जायचं तर third certificate submitted.
एवढा पूर्ण एवढा तो एवढा 322 फ्रेश आपण फाईल करून
बाईचे मगायचं
the Reliance Council for this IA number 1482 of 2023 is an application for interim bail filed by the appellant number 2, namely Shyamdev Kumar. The medical document in regarding the ailment of the wife of the petitioner, which has been annexed to the interim application, is dated 30/6/2020. Let the Land Council for the petitioner obtain a trace medical certificate regarding the ailment of the wife of appellant number 2 and file it with an affidavit and giving copy thereof to the Land Council for the state. Both of this matter, the commencing from such and so. Yes.
Item 25.
Yes, Mr.
Yes, please.
Bari.
My lord, I am from DC.
Oh.
My lord, the appellant has
My lord,
Seven.
my lord, I am this matter through virtual mode.
Yes.
My lord, there are two appeal listed for hearing on bail and suspension of sentence. It's appeal number 604 and 605, Lordship. Lordship, as per the FIR charge sheet and the impugned order, the date of arrest is 23rd of July 2019. So if we add up all the years, it appears 4 years and 5 months till today. And custody certificate I have not filed yet.
All right, let Guardian Council for the state obtain the custody certificate. Which jail he is now?
Lordship, it's Kodapur jail.
Both this plan
Yes, Lordship. Both Lordship. 604 and 605.
is note down and
Kodapur.
obtain the custody. All right, all right. Yes.
I'm obliged, Lordship.
Item 28.
Yes, Mr. Mahanti. Next.
Item 34.
With the here, the petitioner has been convicted.
What is the application, Mr. Panda, you are moving?
PLB.
No, what is that IA number? In the cause list, there is no IA mentioned. It is only for that surrender certificate and etc. Have you filed any IA?
Look, that IA has that earlier IA been put up? Because only interim jail was
No, there is no IA at least. The last time it was taken up before Honorable Justice Sasikanth Misra,
Yeah.
and you were granted interim bail.
Yes.
Yes, for a period of
6 months.
6 months, and that IA has been disposed of. So no IA is pending now. So when you file the IA, it will be listed.
No, may I pray one thing?
Yes.
Lord, you may call it down the next week.
Correct. The Mr. Devasis Panda Land Council for the petitioner submit that the appellant intends to file an interim application for bail. The matter will be listed immediately on filing of the IA. Yes, next.
The surrender certificate is not.
No, that is those are things.
Item 35. Item 37.
Sitting but I know. There are the listed on the sentenced to undergo 10 years in because of imprisonment and to pay fine of rupees 100. Once he was released on interim bail, when during trial for 3 months and during
No, have you got that custody certificate?
and it is there in the judgment and from the surrender certificate. I can show you. Phase 3 of judgment is written for cinema trial. That are say
Yeah, I know to Arasupta near to the guidance of Ochi Anijandi. Okay, CRL number 852 of 2022. There is an application for that is IN number which is 2853 of 2020. It's an application for bail. Mr. Pandal and counsel for the appellant submit that the appellant is in judicial custody for more than 6 years.
6 months.
Achha, more than 6 years out of 10 years of sentence imposed by the land and tribunal. Let the land and counsel for the state who jail katha koijan produce the custody certificate of the appellant. Also the appellants in the connected appeals, that is Keshav Kumar Ture in CRLA number 616 of 2022 and Sheetal Singh in CRL number 619 of 2022. Please appear the order be handed over to the Land and Council for the state 18th of December 2023.
Something like CRL number 619 discussing the certified.
आज तो बेल किसी नहीं
ना आगे तो आदमी
अच्छा एटा तो दरकार नहीं शीतल सिंह रा किसी दरकार नहीं
आगे तो हम लोग डिस्कसिंग हो गया
अच्छा आईएन अच्छा ठीक है जी जो आई सीआरएल नंबर 6 अच्छा सेटा था उससे ऑर्डर था तापर 619 ने लिखूंगा आईएन नंबर 2285 ऑफ 2023 बेटा कहेंगे बात तो 619 कोई लिख रहा the IA number 619 of 2022. IA टा कहीं
double 285
double two is कहीं IA number 2285 of 2023. There is an application for dispensing with filing of certified copy of the judgment dated 14/7/2022. Impugn judgment letter 14/7/2020. You have filed the Xerox copy.
yes
The Xerox copy of the judgment has been filed and counsel for the petitioner submitted that since the certified copy of the judgment is available in the connected criminal appeals, the filing of certified copy will dispense with land counsel for the state has no objection. In view of the submission, the filing of the certified copy of the judgment of the land and trial court is dispensed with or admit call for the trial court report. Interim applications for bail, that is CRL number, IN number 1187 of 2022 shall be considered after receipt of the custody certificate of the petitioner in connection with CRL number 852 of 2022. Yes, next. Sabu water. Yes, next.
Item 38.
Yes, Mr. Tripathi.
section 39.
It's not the convicted on section 376 D, madam.
Sentence in. So, is it your bail application was earlier rejected?
No, madam.
Have you given the deposition copies?
Yes.
Who is the victim?
PW.
Doctor
Dr. PW.
supported the prosecution case.
But after some extent I supported my lord. At my lord on the day that last day of the year, and they are waiting for the new arrival of the new year, my lord. There is a DJ program, my lord, and this victim had gone to her husband's house, my lord, because he has left the husband's house for about more than 6 to 7 years, my lord. Because her child was there, he had come, and there was an altercation between in her family, my lord.
No, she has supported the prosecution case as I have gone through it. So, what is the period you have undergone?
Period undergone, my lord, more than 5 years, my lord. I have been in custody since my lord 2119, my lord.
So you obtain three things. One is about the custody certificate that you obtained. Number two, about the criminal antecedent and also the status of the victim. Alright. He has not received anything. The guardian counsel for the appellant state seeks some time to obtain the custody certificate, the status of the victim, so also the criminal antecedent, if any, against the appellant put up this matter after ensuing Xmas holidays. Yes.
You may be taken up next with
The guardian counsel for the petitioner seeks for an appellant seeks for an adjournment case is adjourned. Yes, next. फाइल करना दिखाएं कि ऐसी हो आइए तो फाइल कर लेकिन ऐसी हो ना आइए नहीं तो कर आइए वाला जो जोड़ा का आखिर आइए जो फाइल है सब डिस्पोज हो गई तो आइए फाइल को ऐसी हो लिख दो जी कहीं आइए इस फाइल को यस नेक्स्ट
Item 41.
glance the order of the was dated 11/7/2020. Out of 10 years, 11/7/2023. My lords, after going to the evidence, after going to the record of past not directing, so file is it comprehensive.
13 criminal antecedent.
Yes, I filed it. In fact, there is no 13, 11, including this case. There are 11 cases, out of which 4 cases he has been acquitted, and 6 cases he has been he is on the bail. Other one is the present one. You also see the 13 number of cases that is of December 2020. In fact, such a case is not registered. That is what I was going through the police.
Now, what is this case? What is the offense here?
Offense under 326, 458, 34. Convicted under 326, 458, 34. And before the similar situated appellant was released on bail by my lords on 3/5/2022 in the criminal offense.
No, because of your criminal antecedent, this is a case where the allegation is about the Dadapati assaulting by means of a gujali on the head and other parts of the body. And what are the injuries sustained by the Mr. Tripathi? Who is the injured and what injury has been sustained?
That is attributed to the person who has been released on bail. He is then similar 14. That your also
Who is the injured first?
Injured PW. And the order is specific.
And
take a note of the evidence of in criminal appeal number.
Wait.
61 or 35.
Who is the doctor?
No, there is a doctor is diagnosis is PW4. And the doctor is PW2.
Judgment of PW19 is the doctor. who has noticed 18 incised wounds on different parts of the body, put up this matter after ensuing Xmas holiday. Yes.
That is attributable.
Next. Yes. तेरटा क्रिमिनाल एंटीसीडेंट 18टा इंजुरी करछंती एई केस अन्य पैसे वर्तमान एक्समास रे पूरी लोक तो एक्समास रही गया सब आसिले माने बहुत असुविधा करी बाहर यस नेक्स्ट
Item 40.
यस मिस्टर पटनायक
Item 47, 70. In the condition for 10 years. 6 months, 6 years or 2 months something custody.
फाइन कस्टडी सर्टिफिकेट का अच्छी कि अपन बारे आनिचंदी मगे
Yeah.
so look on the land council for the petition appellant submit that out of 10 years na
Yes,
10 years sentence imposed by the land tribunal. He has instruction that the appellant has undergone more than 6 years. 6 years of sentence. Let the land council for the state. For the 4 year lachi koi dun. Then next week also 18 tarikh. October 12 there is custody certificate. Yes, next.
Item 43.
Mr. Jina Panda, you will do this.
The appeal against the conviction. I am praying for bail.
Yeah.
What I have asked in my petition and before your lordship is that the entire trial is vitiated because the excise officers are not authorized milords either to investigate, find here and prosecute accused under the
We'll hear after the Xmas holiday. It will take some time. Xmas holiday, yes. Next.
Item 44.
Yes, Mr. Divedi.
defect is if defect number
IP कौन सा
not just court below has not put his signature at page 51 year also. Page 51.
or admit call for the trial court report. What is the sentence here?
20 years, 10,000 fine. I've taken this case on the ground of mother illness.
Interim applications for IA so and so to be considered after receipt of the trial court report. What is the IA that mother?
2727 of 23.
IA number 2727 of 2023. This is an application for interim bail on the ground of ailment of the mother of the petitioner. Learning counsel for the state shall obtain instruction on the interim application.
Next week, my lord, LCR is CRLA number 1244 of 23 and 418 of 23.
Stated that the trial court record is available in CRLA number
1244 of 23 and 418 of 23.
Sleep पे लिखी दी
Copy will be supplied.
copy of the interim application we saw.
Now,
My lord,